Hi everyone, today we're going to talk about co-poaching agreements. What is a co-poaching agreement? A co-poaching agreement is an agreement between two or more companies not to recruit each other's employees. These agreements are often used to protect the company's trade secrets and intellectual property. Why do companies use co-poaching agreements? Companies use co-poaching agreements for a number of reasons, including to protect their trade secrets and intellectual property, to prevent their employees from being recruited by competitors, to maintain a competitive advantage, to avoid costly and time-consuming lawsuits. Example of a co-poaching agreement. Imagine that Company A and Company B are direct competitors in the tech industry. Both companies have valuable trade secrets and intellectual property that they need to protect. Company A and Company B decide to enter into a co-poaching agreement to prevent each other from poaching each other's employees. Under the terms of the agreement, Company A and Company B agree not to solicit or hire any employee of the other company for a period of 2 years. This means that if an employee of Company A wants to leave and go to work for Company B, they must first wait for 2 years to pass. If either company breaches the agreement, the other company is entitled to seek injunctive relief and damages. Injunctive relief is a court order that can be used to stop the breaching company from continuing to breach the agreement. Damages are monetary compensation that is awarded to the non-breaching company to cover the losses that they incurred as a result of the breach. Co-poaching agreements can be a valuable tool for companies to protect their trade secrets and intellectual property. However, it is important to note that co-poaching agreements may be considered anti-competitive in certain jurisdictions. It is important to consult with an experienced lawyer to ensure that a co-poaching agreement is legal and enforceable in your jurisdiction. I hope by watching this video